Hi, my name is Joseph Beige. I'm a real estate attorney on Long Island, and I'd like to welcome you to today's program. For our returning followers, I really appreciate all your support. Thank you for the encouragement. If you're a new viewer and this is your first time checking us out, let me explain a little bit about what we do. With the help of a guest, I'm going to discuss a real estate-related topic with a very simple goal in mind: to help you, the Long Island real estate consumer, make a better, more informed decision on your next real estate transaction. Now, in today's program, we're going to return back to a little bit more of the nuts and bolts in the process of a mortgage and a loan process, how that comes about. And we're going to be talking about the closing and specifically about the bank attorney. Now, the one thing that all loans have in common, whether you're talking about buying a house and you're getting a mortgage to pay for it, whether you're refinancing or taking a home equity line of credit on a current home, or you're a retiree who's looking at a reverse mortgage, or even somebody who's borrowing money privately on what we call a hard money lender, everybody will have a bank attorney, somebody representing the lender. But most people don't really know what that person does, how they do it, how to work with them to make that transaction more efficient and smoother, and also where the legal lines of who they represent and what they can and can't do for you, the borrower. I'm joined today with my good friend, Chris Delisle of Puleo Delisle. And I say good friend because Chris and I actually go back to before either one of us were in law school. Yeah. Actually, I think we probably knew each other before we even thought about law school.
This is true.
Which shows us one of us aged very well, and it's pretty obvious which one didn't. But thank you for joining us today, Chris.
Thank you for having me, Joe.
Chris, before we get going, nobody really cares about our personal background, but in terms of your professionally, tell us a little bit about Puleo Delisle and how you came about to become a bank attorney.
Sure. So my name is Chris Delisle, and I am the managing member, one of the managing partners of our law firm, Puleo Delisle. Puleo Delisle is a law firm dedicated exclusively to real estate with a high concentration on lender representation. While we're headquartered in New York, we are licensed in 9 different states, but our primary focus, and for today's podcast, is for New York representation. Like I said, our office is located in our headquarters in Smithtown, and we're grateful to be here, Joan. Before we get started, I actually just wanted to share with you that I am grateful for the opportunity to share some of our experiences with you and your viewers today, because every day, and it happens multiple times throughout the day, when we go to closings, we see and we view such anxiety and such concern over a lot of consumers when they're making the largest investment of their life. So for us to be able to share some of our experience that may mitigate some of these potential fears and anxiety, I just wanted to say thank you for having me today.
No, I appreciate that, and it's a pleasure. And it is an anxiety. I have clients who walk in and they start looking around the room and they're like, okay, I know you're my attorney. Who's this person? Who's that person? Who's this? Yeah. Because there's just a room full of strangers. Yeah. And like you said, a lot of stress.
And they don't do it every day.
No. And even the attorneys you could see the attorneys who don't do it every day because they walk in and they kind of have that same deer in the headlight look. Just real short, what is the history of Puleo Delisle?
So Puleo Delisle, we are, like I indicated, we're licensed in actually 9 jurisdictions. And Puleo Delisle, we started working with one of our national lenders, Bank of America. And Bank of America had us working in New York for them specifically. And then we did a good job. And then they asked us to expand our jurisdictional footprint, which allowed us to grow into these other states with the understanding that we would be able to work with them in those jurisdictions. That business was enabled us to be able to expand our client base to over 80 lenders right now that we represent on a multi-state basis.
Let's get back to our topic a little bit.
Sure.
Now, bank attorney, when you ask somebody, and this includes attorneys, but it's one of those where, what does a bank attorney do? And they say, oh, they represent the bank. Well, it's kind of like saying, well, what does a surgeon do? They operate on patients. It doesn't really tell the full story about what a bank attorney does. So, in short, what are the things that a bank attorney does when they represent, obviously, they represent the lender?
I think first I would like to just clarify. Bank attorney sometimes is also referred to as settlement agent. And I want to bring that up because it does sometimes cause confusion to the consumers and also to some of the parties in the transaction. In New York, the representation of a lender is the practice of law. Therefore, we're deemed a bank attorney. In other jurisdictions like Florida or New Jersey, it's not the practice of law. And they're referred to as settlement agent. So sometimes when you hear bank attorney, you hear settlement agent, they're one and the same, they're synonymous, but it's important to note in New York, it is the practice of law, and therefore we're deemed bank attorneys. Our approach, and again, the technical term is we're representing the legal interest of the lender when they're providing a loan to a consumer. The means to that end is pretty simple. Whether they are doing a purchase money mortgage, as you referred to, a refinance, a reverse mortgage, a commercial loan, our job is to represent the lender, and represent the lender. Our means to that end is 3 steps. We have 3 quality assurance steps that we utilize to represent all of our lenders. And it's simple. It's pre-closing, it's closing quality assurance step, and the third is the post-closing quality assurance step. I think it's important to note that a bank attorney is really a facilitator. When you're dealing with a real estate finance transaction, there's sometimes a lot of parties like you just referred to. On a purchase, you have a buyer's attorney, a seller's attorney like yourself. You have a title insurance company representative. Sometimes you have the loan officer there. So there's a lot of moving parts associated with the closing. So I like to think of the bank attorney in our legal representation of the lender. What we also do is we facilitate, analogous to a quarterback, if you will. We are going to make sure that we identify all the requirements for that loan. And then we're going to create an harmonious communication platform between all the parties to achieve our objective of getting that loan over to the finish line. How are we doing that? Like I said, 3 steps. The first step is pre-closing. The pre-closing aspect of us representing a lender has us review some of the pertinent documents for the closing, such as the first thing is the contract. A contract of sale, specifically in a purchase, has the parties. What we want to do is we want to verify who the seller is, who the buyers are, and how they're going to be taking title. We want to know the terms of the loan. We want to know the specific dates associated with the loan. What we do may not be overly complicated, but one of the things, believe it or not, that becomes the biggest wrinkle, and you probably would agree, is the logistics of scheduling closings. Because typically, if we're going to a new closing, the buyer has to sell a house. The seller of the house we're buying is buying another house. So it's very important when we do that contract review, which is one of the steps of our pre-closing, we want to make sure that those dates are addressed and any general terms of the contract. Second item that we do under part of our pre-closing process is that we want to do a title review. Title review is critically important because by the time the loan gets to us, this mortgage loan, the bank has already made their business decision. They've reconciled the borrower and they made the decision to give that borrower a loan. But now it's our job to represent and secure their interest. That title review is a very critical part. And the reason why that title review is a critical part is because the bank, while they're giving you the money based on your credit and your debt to income ratio and your income, what they do is they want to protect themselves by collateralizing your property. That's really what the mortgage document is. It's a legal document that establishes the rights of the lender when they're giving you money.
Right. The way I always explain it to clients is that, make it simple at a closing, as I say, the note is the IOU, the mortgage is the collateral. Don't pay the IOU, they come and they take the house.
Exactly.
Now, real fast, I want to just, while you're on the title issue, I know there's certain typical things that pop up. Some of them, obviously we'll discuss, are common to us. Old mortgages, ancient mortgages that'll show up, judgments, things of that nature that a title company will typically take care of when there's a buyer's attorney. When there's, and we'll get into what happens when there's no attorney representing the borrower. But what type of things aren't an issue for the title company, but would be for the lender? Now, I'm old enough to remember at a time when decks were a big issue. If a lender saw a survey that had, or lender's attorney saw a survey with a deck on it, we had to jump through hoops to show them that it was ground level and it didn't need a permit. Then that kind of fell out of favor and no longer became an issue. So on the title issue, what are some of the things that would typically not get caught by a title company or not be raised as an objection by the title company, but would be a problem for the lender?
Great question. What, in furtherance of us ensuring that the bank is in first lien position in the title insurance policy, the title insurance really only affects the property in the sense of the land. They want to make sure that there's no other priority lien holders or owners that have a right to that land. What we're referring to is less about the land and more about the dwelling, which is not part of the insurance policy. So above and beyond the title insurance policy, us as the bank attorney, we want to review to see if there are, in fact, any open permits that are going to be open because maybe they applied for the permit for the deck, but they never closed it. Or in your example, they didn't even open up the permit, but you see the survey, you see that there's a deck, but it's not described. Typically what happens there is that we're going to request, our wish is that there be a permit open and ultimately closed for any of those items that are not title related, but could have an impact on that property. Very often, like we were just saying, it's very time sensitive, these closings. So very often, if we do see an open permit, or if we do see a discrepancy on something such as a deck in your example, if we can't get it closed out in time, very often what we'll do is, from a practical perspective, we'll talk to all the parties. We'll speak with our client, the lender, the buyer's attorney, and the seller's attorney, and we'll come up with potentially an escrow agreement. That escrow agreement may allow us to hold money in escrow. And if the escrow agreement, it's very important, is properly drafted where it identifies specific individual responsible parties, if you will, and who's going to do what in what time frame. But to answer your specific question, that's a good example. Also, another example is if you have a CO, right? If you have a CO for a one-story dwelling, but then it comes back on the survey and you see that there's a second story, similar scenario. We want to get some answers. We would love to have a permit open and closed. If we can't, sometimes the best route is to hold some money in escrow with everyone's approval.
Now, I want to just focus on something real quick because you and I kind of glossed over it, I think. And that's, we talked about the dwelling and that why you'd raise an objection or you would have questions, things that would need to be answered to protect the lender. But it may not be obvious to somebody watching why. When we talk about the title part of it, they understand, yes, priority of liens, making sure that the seller had the right to sell it, that the bank's going to be in first position, there's not going to be a tax lien or an old mortgage sitting in front of them. But when we talk about the dwelling, why is it important to the lender that's lending the money that the dwelling be, for lack of a better term,
compliant?
Compliant.
Yeah, good word. Because very often, whether they're very often a bank gives a loan. And when they give their loan, they provide that loan, but they have they already have a plan for that loan. It's big business post-close. And I'm sure any of us that have mortgages, right, you see that you have a mortgage, you take it out with company A, but sometimes multiple times you're paying a different lender or a different servicer. Banks take these loans, they pull them together, they sell them on Wall Street, they sell them to investors. Those investors and those on Wall Street, they're going to do a review, not of every file, but of a percentage of files to make sure that, to use our word, the dwelling is compliant for the loan that they gave. And the reason why they want to do that is in the event that they have to enforce the mortgage, in the unlikely event of a foreclosure, they want to be able to make sure that they don't have any issues in taking that property back, God forbid, and they have to sell it. They don't want to have to deal with any of those permanent issues.
To use an analogy, it'd be like if you have two cars, and if you're lending money, you want to buy the car that's in good shape. The one that's got a dented fender, ultimately, if you have to take that car back or you have to foreclose or repossess the car, you're not going to get as much value for it. So if you're lending the money to the borrower based on a house being 100% compliant, and it turns out to be 90% compliant, the market value at the time of foreclosure may be less, and then your collateral's less. You made a bad business deal.
That's a good analogy.
Now, we talked about, again, the building permits and things of that nature. And you did talk about, that you reviewed the sales contract.
That's part of one. That's step one of our three-step process.
Now, what are the type of things or documents, modifications that you may need of the contract or documents that you may request of the parties prior to the closing?
You may see that we have to, I keep referring to the date. Sometimes the date might have to be addressed because they have to give an extension. All the parties need to agree to it. You may see that when they apply for the loan, the value of the property is there, but there might be an issue with the buyer or the borrower, if it's a refinance, that their income doesn't qualify. So they may have to add a party. They may have to add an additional person to that transaction. There also may be, we have one that we're working on right now, where they went to contract, and they have an agreed upon purchase price, and they started processing the loan. They started processing the loan, but the home inspection came up with something where it was a major issue. The burner was emitting too many COs, carbon monoxide. And as a result, it was unhealthy to live in this property. The buyer had 2 young children. The realtors did their job. They communicated amongst all parties. The seller agreed. They gave a $10,000 repair credit. We didn't want to reduce the purchase price by $10,000 because then you have to start the whole mortgage loan application again. So that's another example of an amendment to a contract, is that they gave a repair credit in the contract after they went to contract, but before we went to closing.
So again, it's also like confirming the way the deal morphs,
correct,
or changes as it goes forward. The bank attorney is kind of following behind a little bit to make sure everything matches up. Interesting. Now, there's oversight. You talked about, again, the first part, you kind of cut you off when you were in the middle part. But there's federal oversight, state oversight, things of that nature. Do you want to just hit on a few of the things?
Actually, one, which is wrapping up our first quality assurance phase of pre-closing, we have to make sure that there's proper disclosure to the consumer. In 2015, the CFPB, Consumer Financial Protection Bureau, they implemented a much better process to give transparency for consumers of mortgages. So now they require a closing disclosure. A closing disclosure is a very transparent, simple document that establishes the loan amount, interest rate, loan payment, the term of the loan, I think I said the monthly payment, and all the costs associated with it. As part of our pre-closing quality assurance review, we have to make sure that the consumers receive that closing disclosure 3 days prior to closing. That's finishing up our pre-closing review, but that's part of the closing oversight from the federal government.
Now, the closing disclosure, the CD is great, but and I don't know if I gave you a warning on this question, so I apologize. I'm catching you off guard. One of the hardest things to understand, and I've gotten definitions, I've been doing this for almost 30 years, and I'm still not sure I got a true definition. What is the aggregate adjustment? When somebody sees that on their closing disclosure, they'll see something on that list. Some of it's pretty easy. They'll see things such as appraisal, escrows, title, things of that nature, which, again, they can either figure out or they can ask. But what is an aggregate adjustment? It's usually an amount that's coming off, it's showing as a minus sign.
Typically what happens is if they have to pick up, for instance, real estate taxes, and typically they're going to pick up the full amount that's due. But based on when the next payment is due and what the date of the closing is, they're going to actually give a small credit. So they're going to take a larger amount, but give a small credit back based on the time that they're closing in relation to when the next tax is due.
Excellent. Thank you. I know I threw that one out at you, but that's one that I've, like I said, 30 years I've heard probably as many different definitions. Everybody asks me a different answer. Now, I want to switch gears a little bit. We've mostly been dealing with or discussing a situation where you have a buyer and a seller, a typical purchase, commercial real estate, whatever it might be. But there are certain loans where borrowers don't typically go in with an attorney. Refinances and home equity line of credit, so HELOCs.
Great example.
So now that's interesting because maybe I want to discuss with you because you're now sitting there as the only attorney at the table. And that creates a little bit different dynamic between you and the borrower. So first off, in that situation, you still represent the lender exclusively, correct?
Correct. You're right on point. We represent the lender. We do not represent the borrower in that refinance.
And at what point now, how much help can you give the borrower and where is that fine line?
Typically, from a practical perspective, if they have any questions regarding the loan, we push them back to the loan officer or the lender to get that answer. If they have any specific legal questions associated with the loan, we're really not permitted to answer it. But I think it's important to note, going back to your question about the federal oversight, when you have a refinance, there is a 3-day right of rescission granted to the consumer. And what does that mean? That means that they sign the loan on a Monday. They have Tuesday, Wednesday, and Thursday to take their loan documents and ask any questions that they may have, legal questions, to their attorney or to their loved ones or some confidant. And then they have all the way up until Thursday night, in my example, to rescind that loan if they're not able to get that answer. And then that loan ultimately funds or disperses on Friday. So important to note, we do represent the lender. I appreciate you bringing it up. We don't represent the lender. Could we potentially answer a generic question that they may have when it comes to how homes are held, generally speaking, rights of survivorship, without a rights of survivorship? Yeah, we can provide general information, but we cannot provide any detailed legal advice pertinent to their loan.
So when you get to that question, you say, I really can't answer that, or I can't advise you, that at least advise, the borrower there, the consumer says, okay, well, now I got 3 days and maybe the light bulb goes off that they should go now seek an attorney to answer that question.
Correct. And just so you know, as an accommodation, we'll even say, if you want, you can get your attorney on the phone now from the closing table. We can speak to them to your question to make sure that they understand it. We've done that before too.
Now, when it comes to title defects on those types of loans, again, HELOCs, refinances, where you don't necessarily have an attorney on the other side to do the running around, how do you handle with those when they come up?
So we really roll our sleeves up and we're working hand-to-hand combat with the lender. The lender will communicate to the borrower, right? Because while we're not representing the borrower, therefore we don't really communicate with them directly, we'll explain to the bank what we need. We'll work with the title company, and we'll work with the lender who will communicate with the borrower to achieve the objective of clearing any encumbrances that we're going to see on that title.
Excellent. Now, let's kind of loop back again. We're at the closing table. And, again, obviously, I think anybody watching this now realizes the lending attorney, the bank attorney, does more than just bring in a stack of papers and tell you where to sign. So you're at the closing table. What are your main focus there? And what should the borrower be knowing and how they interact with the bank attorney at the closing? So
I think I gave the analogy before, like the bank attorney is the quarterback, if you will. The closing is analogous to hiking the ball, right? Ready? Right? Hike, we're ready to go. The play's in action. Our first order of business, depending on the lender, we're either preparing the mortgage loan documents, or if it's a lender that prepares their own, they're preparing them, and then we're QCing them. First step that we do. Because we want to make sure that everything is in order exactly the way that they have proposed it to the borrower. Number two, like every borrower, you're unique as a borrower, I'm unique as a borrower. Because every borrower is unique, every loan is unique. The closing instructions with every loan is unique. So that's the other thing that we're addressing at the closing, that we're going to make sure that anything specific to that loan, it may be to qualify for that loan, the borrower needed to pay a higher interest loan, a credit card, if you will, in order to be able to qualify for that loan. So we're reviewing or preparing the documents. We're making sure that the closing is facilitated. So then at this point, what we're doing is we're making sure that everything gets properly signed, dated, and notarized. We're making sure that we're in possession. We talked about title curative a lot today. We're in possession of that title insurance policy from that title insurance company, ensuring our client first lien position. And finally, our last step and our second quality assurance step of the closing piece itself, hiking the football, we're dispersing that loan. We're dispersing that loan in accordance with that closing disclosure and to everyone's agreement, which they already signed all the documents. So that's the closing, and that's the main meat of the closing itself.
Excellent. And there is one point with the closing I want to point out, because every now and then I get in a client who insists they always want everything as a bank check or at the closing. Yeah. And I have to point out that the attorney who's representing the lender, it's coming from their escrow. And that escrows don't get messed, that is the one thing that is an absolute immediate disbarment. Yeah. And if an escrow check bounces, your immediate investigation. So if you want, just put a little more meat on what that means. You have an attorney escrow account and how, what that really means to the borrower.
So from a practical perspective, you're completely right. They're good funds, right? They're good funds in this sense that that's our fiduciary account, our law license is in a line. But from a practical perspective, a lot of people don't want to wait, because even though it's an IOLA check, it sometimes has to wait to clear. And like I was saying about the logistics before, sometimes they need that money to go to the closing of the seller is going to closing for the purchase that afternoon or the next day. So they don't want to wait, or they can't wait. So very often they're going to want certified funds or a wire in lieu of an IOLA check. That's a practical perspective. So yeah, you're right. An IOLA check is good funds, but practically speaking, more times than not, they want something other than an IOLA check.
And again, like I said, it's a practical matter for the large checks and the large amounts. You always do that. But I always feel bad when every now and then I get a client who it's insisting on a bank check for $1,000 from the attorney. And I'm, trying to, I apologize profusely to the attorneys at that time. So we've gone through the closing. We're now at the third step, post-closing. Mm-hmm. What are you as the bank attorney doing that now everybody else isn't going to see?
So post-closing, we are first and foremost going to reconcile the recordation of all the legal documents. So while the title company is the fiduciary to take the legal documents, which is typically on a purchase, a deed, and a mortgage, or just a mortgage on a refinance, it's our responsibility to engage with the title company and get confirmation that everything was properly recorded. The next step of our post-closing is to ensure the saleability. I already kind of touched upon it. A lot of these loans are going to be pooled together, packaged together, and sold. It's our responsibility that at the origination piece and the closing piece, that loan is easily saleable by making sure that some of the things that we touched upon have been met and addressed. Excellent. And properly done. And the last thing that we do in the post-closing is we do an internal audit to ensure the enforceability of that loan. Again, the bank is collateralizing that property in furtherance of giving that loan. we need to make sure that everything was done properly post-closing to ensure that in that very slim chance that they do have to prosecute a foreclosure on that property, that everything was done for them to be able to prosecute that foreclosure. So those are the 3 steps of the post-closing.
Very typically, I get it, and I think I hit on it earlier, I get that call from a client, tells me the loan officer told me, I'm clear to close. And they expect me to, and I'm like, wait a minute, I don't even know who the lender is, the bank attorney is yet. Typically, from information for borrowers out there, from the time their loan officer tells them they're clear to close and you first get the file, typically how long does it take you to do your process and get a closing scheduled?
It all depends on the lender. Some of our lenders allow us to take a day or 2. Other lenders of ours, if it is clear to close, they want us to start scheduling the day that is clear to close, because we're running concurrently with the bank as they're getting their clear to close. So we've been engaged with the buyer's attorney and seller's attorney on a purchase, or with the bank on a refinance, to be able to get the title and the clear to close from a legal perspective and a title perspective. So it all depends on the lender. But I just want to add to that one of the things that we always see at closing tables, and this is unfortunate. And listen, you and I don't have a job if the mortgage loan officer's not doing their job, right? So we're appreciative of their hard work to be able to consummate a loan for the consumers. But what I see very often is sometimes the buyer are getting their numbers from their loan officer as to what to bring to closing and how checks are supposed to be cut, as opposed to the professional attorney like yourself. And that's one of the wrinkles that we see, because they go to closing and they didn't bring enough money because the loan officer didn't take into consideration tax adjustments or some other type of adjustments.
Sure. And now, last question. I just want to go back real quick and clarify something on the refinance, the home equity, the HELOCs. As we said, the bank attorney is typically the only one there. However, as I just want to clarify for our viewers, you are allowed to have an attorney there. It is required for a reverse mortgage. Yep. By law that you need to have an attorney represent you. But again, on a HELOC or a refinance, you can have an attorney either at the closing or just Monday morning quarterbacking it from the side for you. And bank attorneys, I would imagine, probably welcome that, because
for sure,
makes their life a little bit easier when they have somebody.
Yeah. I just want to finish one last thing. You mentioned a reverse mortgage, and I'm glad that you did, because we actually close a lot of reverse mortgages, and there is a new law requiring that the borrower, the senior borrower, needs to have an attorney present, and the bank attorney, us, needs to have an actual attorney present. It can't be a paralegal. So on reverse mortgage closings today, there's 2 attorneys at every reverse mortgage closing in the state of New York.
Great. Chris, I want to thank you for taking your time to be here today. I know, even though I've actually worked for you and I've done closed loans, but I always find when talking to you, I learn a lot more, and I've realized how much I don't know about that process, and it is certainly appreciated. I hope you found out a little bit more about both lender closing and Puleo Delisle. If you'll be very lucky if your lender uses them. If they don't, you can always request them, I'm sure, because they are an excellent firm to handle your closing of your loan. Chris, again, thank you for being here. Chris's information will be at the end of this video if you need to contact him. My name is Joseph Beige. I'm a Long Island real estate attorney. My contact information will be at the end of this video as well. If you have any questions, comments, suggestions for future shows, I'd love to hear from you. Thank you.